Hi everybody, I'll be talking about what inchoate crimes are. Inchoate crimes boil down into what I call SAC. It's a very small mnemonic called S, A, and C, which stands for solicitation, attempt, and conspiracy. I don't have a specific order on the board. However, I'll be talking about solicitation first and what it actually means and how important it can be on a criminal law essay, and also for one who doesn't study criminal law to understand what it means in layman's terms in relation to crimes you may see on the news. So let's get into it right now. So solicitation means that when the defendant encourages, hires, or counsels another with the specific intent. Remember, the mens rea for these crimes is specific intent. With the specific intent to commit a crime. Example, A solicits B to commit a crime. Let's say A wants to encourage and counsel and hire B to kill another person. B is a professional mobster. B is this professional person who knows how to kill people. That is his profession. And A goes to B with the specific intent to kill C. A knows that B has this profession. A has that mindset that B is the key way in order for C's life to end. And A hires B. A encourages B to kill C. The moment A goes up to B, knowing that he's a professional mobster who kills people, and says, B, I want you to kill C for $10,000. Right after A says that, he completed the crime. There's no action that has to be said after that. Once A communicates that to B, A is liable for solicitation. Because A knew in his mind, or the mental intent, that B is a professional mobster who kills people, and A wanted, he had the plan, to use B as a key tool to end C's life. Therefore, A is liable for solicitation. Very straightforward with solicitation. Let's get into conspiracy, which can be slightly difficult to understand. However, once I explain it, I believe you'll have a great foundational understanding. So, conspiracy means when two or more people make an agreement with the specific intent to commit a crime. And also, this is very important as well to know, is that there must be an overt act. Without an overt act, there technically cannot be a conspiracy. So let's say that my friend Kevin, Israel, and I want to make this plan to rob the bank. We have the goal in mind that, hey, we want to get some money, some quick money, and we go to US Bank to rob it. Okay, we make that agreement together. That is something that can be communicated between us, and we all make that mutual agreement. That technically can be a conspiracy. However, like I said earlier, there must be an overt act. An overt act means that there must be something beyond the agreement. There must be some type of action to demonstrate that the defendants are actually serious about what they're doing. Okay? In my example, let's say that Israel and I go to the gun store, we buy guns and ski masks, and we still have this specific intent to commit the crime, right? We want to rob the bank with Kevin. We get the ski masks, we get the guns, and we approach US Bank. That is an example of an overt act. Once we finally make that agreement with the specific intent, with the mindset, with the goal in mind to rob the bank, and we make the overt act by buying the guns and the ski masks, that can constitute a conspiracy. What can make conspiracy slightly tricky is the mild penal code. What I just said was under the common law. However, the Model Penal Code is slightly different. Under the Model Penal Code, there is a unilateral agreement, which means that one party in the agreement with the specific intent to commit a crime had the intent to commit that crime, but the other party did not have that intent. So let's say Kevin and I make the agreement to rob the bank, and I had the specific intent to commit that crime, but he didn't. Let's say Kevin is an undercover cop trying to bust me. He's trying to put me in jail, and he wants to talk to me in order to bust me, right? It happens all the time on TV and also real life. So let's say that Kevin and I are in a jurisdiction that goes under the Model Penal Code. If you can see it, right here is the Model Penal Code. Under the Model Penal Code, all there needs to be is a unilateral agreement. And once we have me, Sammy, make that agreement with Kevin, he can technically bust me under law because I had that intent to rob the bank. That's an example of a unilateral agreement with a cop or with anyone else. But more specifically, a cop. That's the most famous example under the Model Penal Code in conspiracy. So let's get into attempt. Attempt is very important. Attempt means when one makes a substantial step from preparation into perpetration. Example, the defendant had the specific intent. Remember, this is a specific intent crime. That's why I put it right here as a sub-point. Specific intent. These are all specific intent crimes. That the defendant had the mental intent to shoot B. The defendant A wanted to shoot and kill B. And A happens to miss. He shoots right at B's. He tries to shoot B in the head. However, for whatever reason, B ends up dodging the bullet. That is an example of A almost killing B, but he wasn't successful. That is an example of him not only preparing to kill B, but he went beyond that. That's why we have the essential step, to get into perp, because the perpetration of the act was A, shooting B, but missing. Therefore, A could be liable for attempted murder because he had the mens rea to kill B. However, the crime was not completed. Another example could be the example I said before. Kevin, Israel, and I want to rob the bank. However, before we rob the bank, we have our ski match, have the guns, like I said before. We have a completed conspiracy, and we're almost at the bank. However, a cop happens to pull us over, and he finds out that we're going to rob the bank. That is an example of Israel, Kevin, and I being liable for the crime of attempted robbery. So let's get into Pinkerton's rule. Pinkerton's rule is something I want to add to along with withdrawal, because Pinkerton's rule and withdrawal are very, very critical when it comes down to thinking about what SAC, our mnemonic, really is. More specifically, when it comes down to thinking about conspiracy, it's very critical to bring up Pinkerton's rule every time you see conspiracy on a law school exam. So let's talk about what this means. So Pinkerton's rule means that all co-conspirators are liable for all foreseeable and natural acts of their co-conspirators. An example of this is my example that I said earlier. Kevin, Israel, and I robbed the bank. Let's say we successfully entered the bank with our guns, we have the max on, our identity is hidden, etc. We walk to the bank, and Israel happens to kill the bank teller. And Kevin happens to shoot one of the innocent people who have to be in there to get some money out of their account. That is an example of a foreseeable act. Although I didn't commit that crime, I didn't kill that person. I didn't kill the bank teller. That was Israel's act. That wasn't something that I did. Kevin killed the innocent bystander. I didn't kill the innocent bystander. However, because I agreed with them and made that overt act with the conspiracy to commit that robbery, and I was with them in the bank, that is an example of a foreseeable act that could happen. Because it is foreseeable that when we have guns and we rob a bank, it's pretty foreseeable that someone could die in that act, right? So that is an example of Pinkerton's rule, because although I did not kill that person, I could be liable for the acts that they commit. That's under Pinkerton's rule. Or you can call it Pinkerton's doctrine. Same thing. That is what this rule is all about. However, it has to be foreseeable. Okay? So let's say that Israel or Kevin happened to, I don't know, bomb the bank. That's pretty unforeseeable. Okay? Because our mission and our conspiracy was to rob the bank to get money and leave. It wasn't to cause complete mayhem and bomb the bank. That wasn't our original plan. However, because we had guns and we hid our identity, it's pretty foreseeable that someone would die during that commission of that felony. That's an example of foreseeable acts that could happen in that crime. And even though I didn't kill that person, I could go down for that homicide. So lastly, let's get into withdrawal. Withdrawal is pretty simple. It's not a very difficult thing. Just going to erase all this up here. So withdrawal really means when the defendant tries to get out of the crime. Sometimes it's successful, sometimes it's not, and I'll go through what a successful withdrawal is versus what's a complete crappy withdrawal, and the defendant will still be liable for whatever crimes that happen. Okay? So I'm going to put D for defendant. So in withdrawal, the defendant must successfully and effectively abandon the crime and successfully and effectively communicate that he or she is out of the crime to their co-conspirators. And the defendant must notify the police to do everything in his or her power to stop the crime from happening. So let's say that A makes a conspiracy with B. Okay? Withdrawal will be a situation where A wants to get out of the crime with B. A communicates and he tries to communicate and effectively communicates to B that he's out. He gets cold feet, he's out. Whether he tells B, which is the most effective thing to do, is to actually tell your co-conspirators face to face, verbally, not through conduct, but verbally, that you're out of the crime. Okay? That's the best way to get out of the crime, and to also ensure that they understand that they're out of the crime, and also that A not only informs B that he's out of the crime, but he also notifies the police in order to stop the crime from happening. If A does not effectively and successfully communicate his withdrawal to B, and if A does not notify the police to stop the crime overall, A will still be liable for every crime that B commits. And don't get me wrong, once this defense, is the defense for conspiracy, by the way, once this occurs, A will still be liable for conspiracy. However, A just won't be liable for any foreseeable natural acts that happen when B commits those crimes in the conspiracy that they had in the beginning, right? This example I used before. Israel, Kevin, and I want to rob the bank. I get cold feet. I get scared. I'm like, Kevin, Israel, I'm out of this crime. I don't want to do it anymore. I tell them effectively and successfully that I'm out of the crime, and I have to do my part by notifying the police. This is very critical. Notifying the police in order to stop Israel and Kevin from committing that crime, from robbing the bank. This is critical because this will allow me, and also my other example, to not be liable for any natural foreseeable acts that happen. I'll only be liable for conspiracy rather than being liable for conspiracy, homicide, etc. Okay? So that's exactly what inchoate crimes are, and exactly what the Pinkerton's rule means and how it's applied to conspiracy, and also the defense for withdrawal when one is in a conspiracy and has cold feet and wants to get out of it. It's important to know with withdrawal that if you do not effectively and successfully communicate your withdrawal, and if you do not notify the police to stop the crime, you will still be liable for any foreseeable natural acts that your co-conspirators commit. However, if you do successfully withdraw by successfully and effectively communicating and notifying the police, you will only be liable for conspiracy. So I hope I gave you a nice foundational understanding of what inchoate crimes are in relation to Pinkerton's doctrine and the defense of withdrawal. I appreciate you for listening to this video, and I hope you do well.